Question 876. A group of brokers agree to divide a market area into separate sections where only one broker each will be allowed to operate. This is illegal, because it only affects the brokers themselves. B. Illegal, because brokers can only divide a neighborhood in thirds. C. Illegal, because it violates antitrust laws. D. Legal, because no consumer is harmed. Correct answer is C. Illegal, because it violates antitrust laws. The described action is known as market allocation or territorial division. Where a group of brokers agrees to divide a market area into separate sections for exclusive operation. Market allocation is a per se violation of federal antitrust laws, like the Sherman Antitrust Act, and similar state laws, like California's Cartwright Act. It eliminates competition among brokers, limiting consumer choice, potentially leading to higher prices, and reducing the quality of service. The law presumes that such agreements are inherently harmful to competition, regardless of whether direct consumer harm can be proven in a specific instance. Such agreements are illegal and can result in significant penalties for the brokers involved. Question 877. After a buyer gave a deposit to a broker, the seller did not accept the buyer's offer. However, the broker subsequently did not return the deposit to the buyer. In such a case, the real estate commissioner will A. Immediately suspend the broker. B. Investigate, upon receiving a verified, written complaint. C. Do nothing. D. Report the matter to the police. Correct answer is B. Investigate, upon receiving a verified, written complaint. The DRE's primary role is to enforce real estate law and protect the public. They have the authority to investigate complaints against licensees. The DRE typically requires a formal, written, and verified complaint from the aggrieved party, in this case, the buyer, before initiating an investigation into a licensee's conduct. If the investigation finds evidence of a violation, the commissioner can then take disciplinary action against the broker, which may include license suspension, revocation, or a monetary fine. Immediate suspension is rare and usually reserved for cases where there's a clear and immediate danger to the public. It's not the first step for every complaint. For serious violations like misappropriation, the real estate commissioner's initial step is to launch an investigation from a licensing and regulatory perspective. Although criminal charges are possible in severe instances, the commissioner's primary focus is on addressing the breach of real estate law through administrative discipline. Question 878. The separate property of a married person includes the following. A. Property acquired during marriage by gift. B. Property acquired during marriage by inheritance. C. Property acquired with the proceeds from the sale of separate property. D. All of the above. Correct answer is D. All of the above. Separate property is property that is owned by one spouse and is not considered community property. In California, which is a community property state, the law distinguishes between community property and separate property. Separate property of a married person includes A. Any property received by one spouse as a gift during the marriage is considered their separate property. B. Any property received by one spouse through inheritance, bequest, devise, or descent during the marriage is also considered their separate property. C. If a spouse sells their separate property, the funds obtained from that sale remain separate property. Any new asset subsequently purchased using those traceable funds also retains its character as separate property. This is often referred to as tracing. Since all of these scenarios describe property that is legally considered the separate property of a married person, the correct answer is D. All of the above. Question 879. The deadline for a broker to deposit a client check made out to the broker's trust account is A. 3 business days. B. 5 business days. C. A week. D. There is no such deadline. Correct answer is A, 3 business days. In California, real estate brokers are strictly regulated regarding the handling of client funds. When a broker receives a client check made out to the broker's trust account, they are required to deposit those funds promptly. The deadline for a broker to deposit a client check made out to the broker's trust account is 3 business days. This rule is stipulated in the California Business and Professions Code. This ensures the timely and proper handling of client money. Question 880. If a party to a contract unintentionally provides false information that leads the other party into agreeing to the contract, it is called A, misrepresentation, B, fraud, C, dereliction of duty, D. If the mistake is unintentional, then the contract will be enforced. Correct answer is A, misrepresentation. Misrepresentation occurs when a false statement of a material fact is made, which induces another party to enter into a contract. It can be innocent, unintentional, negligent, made carelessly without reasonable grounds to believe it's true, or fraudulent, made intentionally to deceive. Since the question specifies unintentionally, it falls under the umbrella of misrepresentation. Fraud specifically involves intentional deception or reckless disregard for the truth, with the aim of inducing another to act. Dereliction of duty refers to a failure to fulfill one's obligations or responsibilities. While an unintentional misrepresentation might stem from a lack of due diligence, a form of dereliction, misrepresentation is the specific legal term for the act of providing false information in contract law. Even unintentional, innocent or negligent, misrepresentation of a material fact can make a contract voidable by the misled party, as it affects the genuine consent of the parties. Question 881. The following is not a required element for forming a contract to sell property. A, legal capacity, B, offer, C, consideration, D, title report. Correct answer is D, title report. A title report is not a required element for forming a contract to sell property. The title report is composed after the contract is signed. It is obtained during the escrow or closing process to ensure clear title, but it is not a required element for the formation of the contract itself. It is a document that provides information about the ownership history of a property and identifies any liens or encumbrances on the title. While it's important for buyers to obtain a title report to protect their interests, it's not a necessary component of the contract itself. The essential elements for a valid contract include 1. Offer. One party must make a proposal to the other. 2. Acceptance. The other party must accept the offer. 3. Consideration. Something of value must be exchanged between the parties. 4. Legal capacity. Both parties must have the legal capacity to enter into a contract. These elements are necessary to create a binding contract for the sale of property. Question 882. Which of the following actions by someone who has made a declaration of homestead would invalidate it? A. If the declarant records a homestead on a different property. B. If the declarant rents the homestead. C. If the declarant sells the homestead. D. Both A and C. Correct answer is D, both A and C. A declaration of homestead is a legal document that protects a homeowner's primary residence from certain types of creditors. To maintain the homestead exemption, the property must be the owner's primary residence. If the homeowner records a homestead on another property, it implies that the original property is no longer their primary residence, thereby invalidating the original homestead. Selling the property would automatically terminate the homestead exemption, as it's no longer the owner's primary residence. Renting the homestead generally does not invalidate the homestead exemption, as long as the owner continues to use the property as their primary residence. Question 883. A standard title insurance policy would likely protect a purchaser from the following, except A. Lack of capacity to contract by a grantor, B. Forgery. C. Non-delivery of the deed. D. Encroachments. Correct answer is D. Encroachments. A standard title insurance policy primarily protects against defects in the title that are discoverable through a search of public records. It generally does not cover issues that would only be revealed by a physical inspection or a survey of the property. A standard title insurance policy typically protects against title defects such as 1. Forged documents. If a deed or other document in the property's chain of title is forged, the title insurance policy will provide coverage. 2. Undisclosed heirs. If there are undisclosed heirs who have a claim to the property, the title insurance policy will provide coverage. 3. Errors in public records. If there are errors in the public records, such as incorrect property descriptions or liens, the title insurance policy will provide coverage. An encroachment is an unauthorized intrusion of a building or other improvement onto an adjacent property. These issues are typically discovered only by a physical survey or inspection of the property, not through a search of public records. Therefore, a standard title insurance policy generally does not protect against encroachments. An extended coverage policy, like an ALTA policy, often includes coverage for encroachments, but it requires a survey. Question 884. A building's highest and best use refers to attaining its A. Greatest net return. B. Most equitable and socially conscientious use. C. Greatest gross return. D. Tallest height. Correct answer is A. Greatest net return. The highest and best use of a property is the use that will yield the greatest net return to the property owner over a specific period of time. It's the most profitable use of the property, considering factors like zoning regulations, market demand, and potential development opportunities. The concept of highest and best use is crucial in real estate appraisal, as it helps determine the property's fair market value. An appraiser will analyze different potential uses for the property and select the one that maximizes its value. Question 885. A mortgage loan broker servicing a promissory note by releasing funds to protect the security of the loan must provide written notice of this within to the beneficiary of the loan. A. 5 days. B. A week. C. 10 days. D. There is no requirement to notify the beneficiary. Correct answer is C. 10 days. Lenders and mortgage brokers are typically required to notify the beneficiary of a loan within a specific timeframe when they release funds to protect the security of the loan. This notification period is designed to keep the beneficiary informed about the status of the loan and any actions taken to safeguard their interests. A mortgage loan broker is required to notify the beneficiary within 10 days of advancing funds to protect the security of the loan. This notification ensures transparency and accountability in the loan servicing process.